that the whole paradigm had changed here. See, originally it was private money. Now it's public money. In Exhibit 4, it's clear that the legislature said that any agreement, any construction agreement, must incorporate provisions that are consistent with use of state financing. Consistent with use of state financing. And here you have a situation where the state's position is that none of the agreements to build the bridge, except for the original proposal, which we agree that there was a solicitation process, but any of the agreements to build the bridge, there's no rules. There's no solicitation process. There's no competitive bidding laws that apply. And that's just absurd. You're talking about a $600+ million project, and there's no rules. There have to be rules. And the problem here is that if this court, in fact, this court in the P&A case ran up against the same problem because the state was arguing by implication that these tolling statutes were repealed. And what this court relied on is found in Exhibit 5, the same language which says any agreement that is executed has to comply with existing law at the time. Now, I would like to get to my bonding argument very quickly because I know I'm running into my rebuttal time. And I would simply point out if the court were to accept the state's position that this section exempts, Section 13, I think, that you referenced, exempts any and all contracts from competitive bidding laws, you have a problem with EHB 2723, an Article 2, Section 19 problem, because EHB 2723 does not reference in the title or the text any competitive bidding law. References nothing. So you have a problem. It's either these contracts must comply with existing competitive bidding laws, or you have an absurd result where nothing applies. And they cannot rely on 2723 because 2723 doesn't even address competitive bidding. They don't mention it. Finally, let me quickly address the bonding issue. Likewise, in P&A 1 and the state's position, they want you to read by implication amendments to existing law. The key here is found on Exhibit 6. Exhibit 6 is a portion of the state's brief where they say, in essence, that it is not necessary for Referendum 49 to have been amended, that these bonds are and will continue to be payable from the motor vehicle fuel tax revenue. That's not correct. They also say that 2723 provides only that motor vehicle funds will be reimbursed by toll revenue. That is not correct, and let me explain quickly why. If you go to Exhibit 7, this is from the Referendum 49 law, states that the principal and interest of the bond shall first be payable from the gas tax proceeds, and if that is insufficient, the legislature agrees to increase gas taxes. The next exhibit, number 8, says that any funds required for bond retirement or interest shall be taken from that portion of the motor vehicle fund that results from gas taxes. And the problem the state has, and the problem with 2723 is found in Exhibit 9, which is Section 11 of that statute. What that section says is that on or before the debt service date for the bonds issued for the Tacoma Narrows Bridge, the toll money will be moved to the motor vehicle account, then from there to the bond retirement account before each debt service date. That directly contradicts the prior exhibit I showed you, which says that the source to pay off Referendum 49 bonds is first and only and will always be the gas taxes. The problem here is that this would work, this section would be okay if the legislature allowed for alternative or additional means to pay off Referendum 49 bonds. As you know in our brief, on page 21, we went through a plethora of bond statutes that show there are alternative means. I'll reserve the rest of my time. Thank you.
Ms. Kate?
May it please the Court. My name is Deborah Cade. I'm an Assistant Attorney General representing the Washington Department of Transportation. I'm here today on behalf of all of the state defendants, and also with me is Tom Worrell, who is counsel for the Treasurer. The trial court correctly dismissed this case, finding that DOT complied with all applicable law in contracting for the new Narrows Bridge, and also finding that the new legislation addressing the issues in the P&A case and providing for state financing was constitutional, and that dismissal should be affirmed. This is the same proposal that was before the court in P&A. It is a subsequent contract in that proposal, but it is the same proposal. United Infrastructure's contract was not terminated. It was in response to this court's decision and in response to the new legislation was amended. By that time, much of that contract had been performed. And so the contract was amended to delete the items that UIW would not be performing, and the remainder of the contract was completed by UIW, and it was closed. That agreement, and this is included in the record at Clerk's Papers 124 through 129, sets out the roles of the three major parties to this transaction. And those were UIW, DOT, and the design-build contractor. UIW's role included bringing a design-build contractor as part of their proposal, and the design-build contractor on contract now, TNC, was in fact part of that original proposal. They weren't known as TNC at the time. They are a joint venture between Bechtel Infrastructure and Kiewit Pacific, and those two entities were part of the original proposal. UIW was originally, under the original agreement, was responsible for arranging the financing, also for contracting with the design-build contractor and managing the construction and the operation of the project. Since the state is now issuing the financing, it was no longer necessary for UIW to continue its involvement as the project manager. And so in taking over the financing responsibilities, DOT also took over the contracting responsibilities with the other companies who were part of that original proposal.
Counsel, I believe in between this court's decision in P&A and the amendment of the Amendment 2723, there was another statute, 4720, I want to say, 780, referring to design, build, competitive bidding, and how that should go forward. And that statute predated or postdated, I guess postdated the contract between WSDOT and TNC?
You're referring to RCW 4720, which is new authority for DOT to enter into design-build contracts.
Yes, that's what if
okay.
I didn't say that, that's the provision I'm referring to.
Right. That, I believe, was enacted in, I'm thinking it's 2002. I'm not entirely clear on it because DOT already had design-build authority under another statute, and it was recodified under that section. But let me back up just a little bit and give a little comparison between the different contracting authorities DOT has. I think I can answer that question. DOT has statutory responsibility to design, construct, and operate state highways, including bridges, and it can do so by contract. What type of contract it uses and how that contract is procured depends on the type of work that's being contracted for and the stage of project development that the contracting is done. Highway projects are completed in roughly 3 stages, the first being project development, where the planning, environmental studies, right-of-way acquisition, early design takes place. Then they go through a design process where detailed plans and specifications are prepared, and then construction. If the contract is entered into at the time of construction, when detailed plans and specifications are done, then DOT has to use RCW 4728. That is their mechanism for obtaining a purely construction contract. That's the most common method used and is usually referred to as the design bid build method. If they're only contracting for the engineering services, they use the Architects and Engineers statute, which is a completely different procurement mechanism, uses a request for proposals, and allows DOT to pick the best proposal and negotiate the best price. If DOT decides to enter into a contract during project development that incorporates elements of project development, design, as well as construction, then they can use the design-build method. And that is, it utilizes a request for proposals process similar to the Architects and Engineers contracting statute, where DOT can can choose the best proposal. It's a process that's intended to be more efficient because some of those steps are can be consolidated or overlapped, and some efficiencies can be realized. Lastly, DOT has had the ability to at least test the process of doing what they call the Public-Private Initiatives Program with the 6 demonstration projects that incorporates both the design-build process as well as the potential for private financing. That gives DOT the option of essentially hiring one contractor or one team, in effect, to go all the way through project development, design, and construction, as well as operation. This is the process that was used for the Narrows Bridge contracts. And so really the question is whether they complied with the requirements of 4746 as opposed to 4728, or really even 4720. 4720 actually contemplates a very similar process to what was used to develop and solicit proposals in the Public-Private Initiatives Program. It utilizes a request for proposals process. It allows DOT to consider factors other than price and choose projects that are and proposers that meet other state needs in addition to being the lowest cost. And that was the idea behind the Public-Private Initiatives Program as well, to give DOT the flexibility to consider factors other than price. And that's as public contracting nationwide really has developed over the years, that is a kind of a recent trend, whereas back in the 30s when a lot of public contracting laws were written, the issues were getting the best contractor and the best project for the best price. And now there's a more of a trend toward considering other factors that are also in the public interest, such as the schedule that the contractor is going to use, how much time the contractor is going to take and have traffic obstructed by construction, gaining some efficiencies that have been developed in the private contracting arena in terms of using design-build and processes in which the designer and builder can work together more closely and share information and perhaps do the job more efficiently, quicker and more inexpensively.
Council,
So,
if this had preceded this relationship between WSDOT and UIW, or later WSDOT and TNC, and if it had proceeded under 4720, 780, would the personal services contracts that are at issue in this case, would those have been arrived at the same way as we don't know for sure whether these were competitively bid, but assuming that they were not, would that be authorized under a project that was proceeding under 4720, 780?
4720 would only encompass the actual design-build contract itself.
Okay.
The other contracts that were referenced, I believe, were procured under the personal services contracts statute, or more likely, since I believe they were engineering contracts, they would have been procured under the architects and engineers contracting statute.
We don't know because there wasn't sufficient time, according to your opponents, to get that information.
That's correct. However, there also was no information alleged that there was anything wrong in the procurement of those contracts. There was only the allegation made that the contracts existed, and as a state action, it's presumed to have been done in accordance with the law, unless they have some evidence or some reason to believe that there was some wrongdoing done, and they really didn't even state a complete claim on that issue. Well,
then, I guess what your opposing counsel just suggested as being the absurd result under Section 13 is not a result that you would you wouldn't disagree with him on that, because what I asked him was whether or not these contracts that he's complaining about would have to go through some sort of competitive bidding process under Section 13. He said, I thought that it would be absurd if all contracts, including personal services contracts, did not have to be competitively bid, and so 13 shouldn't be read to suggest that all contracts subsequent to a proposal being made can bypass the competitive bidding laws.
What Section 13 addresses is the contracts that would have been part of the original proposal, and that would include the design-build contract and the contract for the tolling system and the contracts that UIW had in the works when they completed their work. And so those are